Hello, everybody. Surprise. Hi, Eva. Yes, hi. Hi. We're getting a little bit of a thunder and lightning storm right now. So they might be a little more clingy than usual. Hello, Jerry Matthew Boyd. Hello, Wire Mother. Oh my goodness, thank you for being the first like of the night. Hello, Buzzy Bug. Hello, Nana Laura. Okay, Snitch, come on, baby. Mr. Snitch is here. Yeah, show everybody your beautiful face. Yeah, that one. That beautiful face right there. Yeah. Oh, thank you, Joey Bag of Donuts. I really appreciate you. Are you giving the doggo kisses? Doggo gets one more treat. Oh, Billy. Hello, Dark Zoomy. Yes. I stand by that, especially after you see the videos tonight. Did I see correctly? Did Sean enter the room? I missed him. Why don't I see Sean? I see a hi, Sean. I see a hi, Sean. Was that who got Joey's membership? Possibly. At any rate, hi, Sean. Hello, Linda Adams, honey. Well, I'm glad you didn't. Pish posh. Hello, Spider-Man. Eileen and Carlin, hello, sweetie. Welcome back. Oh, that's awesome. I'm so happy to hear that. Oh, we were all assuming you went on your trip. But I'm glad you're back now. Trust me, I completely understand that. I went through this whole last week asleep completely. Like, I don't even know how I made it some days. But I am really, really glad that you're here now. How you doing, Nana? We love you. Today is my daddy's birthday. Well, it was my daddy's birthday. All day and part of the night too. as he would say. So it's been one of those emotional roller coaster days because I miss him a lot. He was such a big part of my life. So yeah, it was an up and down day, but a friend helped me get the other cat tree together, so we now have 2 cat towers, and I have some treats on the dark gray one, so I'm hoping to entice them there, and you guys can see them up close and watch them do their thing. Yeah. 100%. Well, you're not supposed to get over it. You hear a lot of people say, get over it. You know, you're not supposed to get over it. You're supposed to cherish the memories and hold on to the good times. And you're supposed to learn to go on in a manner that would make them proud. Because that's all you can do. We have fun stuff tonight. I'm going to put this over here, though. There we go. Yeah. Yeah, they really like the new cat tower. They really like that. The box in the middle has holes on either side and the hole in the top. So they can pop their head out like a little weasel. And it's the if I had to buy it again, I wouldn't. Not this brand. Because almost every platform board had chips in it. It's got this veneer over the press board, and almost every single platform has chips in it. Amazon ended up refunding me for it, and they told me just to throw it away. No, I'm gonna still get use out of it, but I am disappointed in the quality. It's specifically a Maine Coon cat tree. I did that because I have big cats and I wanted them to be able to comfortably be on the platforms without me worrying about them breaking, which has happened. So I got one designed for a Maine Coon, and when I opened the box, like the main platform board had a giant, like 1.5 2 inch chunk just splintered all over the place. Luckily, it ended up being a piece behind one of the poles. Once we got it together, I complained once I found it, not knowing how it would, work in the putting together aspect of it. But we contacted the manufacturer. They told me they would send me a replacement board. In anticipation of getting the replacement board, we started kind of putting stuff together, and we saw little chips everywhere. Not thrilled, but it's together now, and in time they're going to chip it up anyways. So I'm just going to let them do their thing on it, and I'm going to be happy and grateful that I have it at all. Hello, Squishy. let us be the judge of that. Of what? Of what? Of what? I said a lot of things. Oh, Earl is having the time of his life. Hello, Ava. What's up? Do you need one of your chew bones? Oh, Billy's inside of it. Oh my gosh, I love it. I love how they interact on it. Like if it was better quality, if it didn't have all the chips in it, I would say it was a 10 out of 10 product. But I'm disappointed. I'm not gonna lie, I'm disappointed. All right, I gotta get Ava a bone really quickly. I'll be right back. Well, hi, Snitch. Hi, tiny kitten. Hi, sweet tiny baby girl. I know. She saw Snitch and then she had to go. I'm working on it. Oh my goodness. Her storm bones. Oof. Yeah, I started early. I got stuff all edited and I was like, I'm gonna go hang out with my friends. Oh, Billy's gonna jump. Billy's gonna jump. He did it. Yay. Now I'm gonna have to get a light over there for that one. I wonder, I'm just testing something here. Oh, that would work. That would totally work. Looks like I'm ordering another one of these bad boys. That would totally work. I'm not getting more cats. But Eileen has said that I should do that anyways. Nice, Dark Zoomy. Jerry, don't pretend like I haven't already thought of it. Oh, did Morty come in? Hello, Mortimer Duke. How you doing, sweet love? Get him hooked on this. This is much better. I always wanted a small animal sanctuary because I wanted to care for possums and coons and skunks and squirrels. I wanted all of the rodents of the world, I love them. But, well, possums are not rodents. Neither are coons. Or skunk. Squirrels are. I love my babies. I love my babies. Hey, you know what? It's not my fault that they came to me all emaciated and like near death and now they're fat and happy. Like me. have fun tonight. We're going to have lots and lots of fun. We've got an FTC with, oh man, I wish Auntie M was here. I love skunk. I love them. You got to have the scent sac removed to keep them as a pet, but they make phenomenal pets. I love them. I want one so bad. I want one so bad, guys. I would cuddle up with it just like Snitch. Snitch loves to cuddle. They are so happy with the cat tower placement. Billy is all up and on it, and Earl's loving it. This is amazing. I'm so happy with this. I do have to say a really quick thank you to Lone Wolf Usal. The first case, I was so happy that I could run it as an FTC, and then it got to the sentencing or the ruling aspect of it, and the file had cut off, which YouTube does that from time to time. They send some kind of a code and it disables the downloadability. So I was missing the best part, and he shared it with me. I love him. I love Lone Wolf. Lone Wolf and Squishy, my boys. FTC is follow the case or following the case. It's when I have multiple hearings of the same person all in a row.
Court will call the matter of Nicole Brandenburg and Tyler Goff, filed 09-13272-DS. You are Tyler Goff?
Yes, Your Honor.
All right. You're here today on a friend of the court matter. Ms. Kraus, can you update me on this case, please?
Yes, this hearing was adjourned from March 27th. There was an arraignment hearing. The defendant's bond was reduced from $5,300 to $300. Once that was paid, he would be released with conditions. I assume he's not made that payment as he's still listed and housed at the jail.
All right. Mr. Goff, what's your status at the jail? Why are you still there?
Just haven't paid the bond that was on there. So I just didn't really want to, because I'm barely working right now, very, very little. And if I were to pay that, that's literally about what I have right now. So what I'd be able to put on it after that for the month would be, $50 or $25 or something.
What is it that you do for work?
So right now I'm just working for cash with my dad, and it's very little. It's, once or twice a month.
What do you do with the rest of your time?
Pretty much sit around. I mean, I don't really spend time with people.
What type of work do you do with your dad?
So it's anything with pole barns, garages, cement roofing, tile.
So construction work, basically?
Yeah.
It's now the middle of April and good weather is returning. Are you telling me that you can't catch on with some other crew on a more full-time basis?
Well, yeah, probably, or find some other job.
So why aren't you working at that?
Just, slow going kind of right now, slow going,
Well, there's no going because you're sitting in jail and not even trying.
Well, right.
I don't understand that. What's your plan? You gonna sit there for the rest of the summer?
No, not at all.
So what is your plan?
I wanted to get out as soon as possible because I was awaiting a paycheck when I got put in here from my dad. He's actually holding a paycheck for me. I mean, supposed to be holding a paycheck for me. He owed me a paycheck when I got put in here. Like I said, the paycheck is $250, maybe $300. So it would literally cover my bond. After that,
Right. So you got a way to get out. And then what's your plan when you get out?
work with him or find more work.
Mr. Goff, how long have you been out of high school?
16 years, 15 years.
Your answers and your actions remind me of a sophomore in high school. No real plan, just going to kind of float along with whatever happens that particular day, and do whatever you have to do to just barely survive and get by. Tell me I'm wrong.
I hear you. I hear you. No, I'm not saying you're wrong.
Time to grow up.
He hears you, but he doesn't care. Video games are far more entertaining than jobs.
You've got $21,000 in money that you owe on back child support. Do you understand that?
Yes, Your Honor. Yes, Your Honor.
You could buy a very, very nice vehicle for that amount of money. You could walk in and pay cash and buy almost any car on a used car lot right now for that amount of money. And you would drive that car for the next 10 years. And your actions right now are, nope, I don't want to do anything. I'm just going to sit in jail and hope something happens.
Well, to be quite honest, I thought I didn't really quite realize the bond was there. And they pointed it out to me afterwards. Some reason I didn't have paperwork yet. I didn't get paperwork on the matter. The COs brought me paperwork. I didn't even realize there was a bond there written. They brought me paperwork, pointed out the bond. Then I knew a bond was there. They had me gave me the ability to write in front of the court. I mean, I can probably cover the bond. I can probably come up with the bond.
Ms. Kraus, we had a hearing on this last month or a few weeks ago, right?
That is correct. The 27th, it was indicated that he had indicated he had a check. You had asked the amount. He said he could cover $300. That's the reason that the bond was set for that amount. And just so you're aware, Your Honor, a little bit of history on the case. Since prior to this arrest and him sitting there, he was arrested in August of 2025. He served 21 days. Friend of the court did a report to the court on September 10th that he completed his sentence and was released. And then the defendant paid $200 in November of 25, $100 in December, and $50 in January, and then $100 in February. Then he failed to appear because there was conditions again, and then the new bench warrant issued. So this has been an ongoing process for Mr. Goff.
Mr. Goff, what you just told me about not knowing about the bond doesn't make any sense to me at all. We had a specific hearing where I reduced your bond from cash of $5,300 down to a personal recognizance bond, a $300 bond, so that you could get out because you told me that's what you had to get out with. And then here we are 3 weeks or so later, and you're still sitting in jail because you don't want to do anything.
It's not that I don't want to do anything. You know, I thought maybe the fact that I had 3 consecutive months of payments on my child support and fines and costs would make some kind of difference also, but I guess not.
You had 3 consecutive months of steadily reducing amounts that didn't even come close to what you owed.
But
You don't get participation medals. It's not good enough to just do a little bit. Dude, you're $21,000 behind. What don't you understand about that? That's not just a little bit. You haven't made $21,000 in a whole year, have you?
probably not, but you know,
Which is really sad because that's minimum wage jobs will make you $21,000. You just don't want to go out and get a job. I'm not changing bond, Mr. Goff. You want to sit in jail? If you want to sit in jail, sit in jail. That's got to be the dumbest thing I've heard in a long time. But if that's what you want to do, be my guest. We're done. You'll still owe your money when you get out. Next case, you can go back to sit in your cell, Mr. Goff.
all right.
First case this morning is Nicole Brandenburg and Tyler Goff, file 09-13272-DS. We have Mr. Goff with us, please. Mr. Goff, if you could unmute and put on your video, please.
I'm trying to find it right now, Your Honor.
All right, we'll give you a minute. All right, I do see Mr. Goff is now with us. Ms. Kraus, could you update me as to this case, please?
Yes, this hearing was adjourned from April 24th. That was previously adjourned from an arraignment hearing on March 27th when the bond was reduced from $5,300 to $300. But the defendant appeared from the Otsego County Jail on April 24th as the bond was not posted at that time. This hearing today is to address the forfeiture of that bond as that was paid and he no longer appeared on the inmate list as of April 25th. After that, additionally, upon his release, he was to do a few things to report any income that he received and to provide job searches. There's been no verification of income or payments, but he has provided 5 weekly job searches on May 4th, 11th, and the 19th. And then the third condition was prior to today's hearing, the defendant is expected to make payments and to show reasonable efforts to gain employment if they're not able to pay their obligation in full.
He's probably applying for jobs like lawyer, CEO, executive director of marketing, things that he knows he has 0 chance of getting hired for, but he's applied. I actually knew some POS that did that trick. Yep. Wasn't even a high school grad. And he was putting in for legal professions, medical professions, jobs that require an education. And I'm like, why don't you just get a real job? And it was kryptonite to them. How dare I suggest such a thing?
His support obligation is $324 with an arrears balance of $21,725.27.
Thank you very much. Mr. Goff, as to the forfeiture of the bond and application towards your payments, do you agree to that?
Excuse me, can you say that again, Your Honor?
Yes, the child support staff is asking that the bond that you posted, the $300, that be forfeited and applied towards your back child support payments. Do you agree to that?
Yes, Your Honor, yes.
All right, so we will apply that $300 towards your back payments. Tell me what you've been doing to find work.
So I have a couple apps on my phone for job search, and I've just been looking on there and applying on there. I just got some new new apps on there that I'm hoping I might get a job at.
So what are these apps for, and how many places do they search at?
So the one's Indeed and the other one's Snag a Job. They're you can apply to jobs on them and find a job. And quite a few. As far as like as many jobs are on them, there's a lot actually. There's a lot of jobs on them.
How many jobs here in northern Michigan?
There's usually quite a few. Now, it doesn't seem like there's as many on there this time as there usually is, but there's still quite a few.
So how many have you applied at?
I want to say 15 now or something.
In 3 weeks?
Yeah, yeah.
So how long does it take you to apply for a job?
So I've called on a few and haven't gotten them. But usually it
long does
doesn't
it-
take me long. Usually, a couple of weeks and I find one.
The courts required that he submit proof of 5 job searches per week. 3 weeks, he's done 15. He's doing the absolute bare minimum. Bare minimum. He's not even trying.
So I've used them before. I've used them probably five times before or more, maybe even more than that. And it usually takes me a couple weeks or so to find one.
Let me make my question a little more specific. How much time in a single day does it take you to make an application?
It only takes maybe an hour or maybe hour and a half to apply to 5 jobs.
So what are
3,
you
4,
doing
5
with the rest of
jobs.
So what are you doing with the rest of your time?
Not too much. So I went and stayed over at my sister's for a little under a week and just spent time with her. But other than that, I've just been in the house. So I was working with my dad a little bit before I got put back in jail the last time. He's still working, but I haven't worked with him since I've been home. I was hoping just to continue working with him a little bit when I got back home, but haven't worked with him since I've been back home.
How long have you been out of jail, Mr. Goff?
I want to say close to a month now, close to a month.
And in that month's period of time, you have applied to 15 jobs and gotten 0 jobs and made 0 payments. Do you think that that is enough to keep you out of jail again?
I definitely don't think it'll satisfy or fulfill.
Then why are you doing that? Why aren't you out there busting your butt to get a job?
Well, I could try a little harder, I guess.
Well, that would be the understatement of the year. What is it that you need? Do I have to have somebody hold your hand and take you to a job site and ask for work?
No, Your Honor, not at all.
Then what do you need to do?
Like I said, it usually only takes me a couple weeks, if that, to find a job on there. But I guess I just really need to buckle down and put in the effort, I guess.
Mr. Goff, I find that your lackadaisical attitude shows me that you do not have the ability. No, I'm not going to say that. You do not have the desire to make your payments. You've not made a good faith effort to find work. And you have the ability to get a job because you've gotten jobs in the past. You've worked with your dad in the past. You've had other construction type jobs in the past. There are, and I know that I've told you this, there are probably 50 jobs on the whiteboard at the front of the friend of the court's office that are open right now in Gaylord. And the only thing that you've done is play on your phone a little bit. So I find that you've not made a good faith effort to get a job, that you have the ability to get a job, and that you came out of jail because you didn't get a job. And now I'm going to put you right back in jail. You will report to the jail for 7 days, beginning today, May 22nd at 6 p.m. And then when you get out of jail, we're going to have another hearing next month. So you've got 3 weeks when you get out of jail to get a job. And if you don't get a job, you're going to go back into jail again for 7 days. I don't know what to do to light a fire under you, but this is what I'm going to try next.
So the
there's
bond
no
is just doesn't count for anything?
The bond got you out of jail last time. You're the one who wanted to stay there last time. So you got out for 3 weeks and you did nothing for 3 weeks after being in jail. And the best you can tell me is, I guess I should do a little bit more. No, there's no more guessing. You've been playing this game long enough. Okay, you're $21,000 behind. Grow up, get a job. And because you haven't in the last 3 weeks, you're going to jail for 7 days, starting today at 6 p.m. You're free to go until 6 p.m., Mr. Goff, and then you're at the jail. That's all for today. All right, the court will call the matter of the state of Michigan versus Timothy Wiedeski, file 26-44590-FY.
I would not want to be the guy that goes as the next case after that. Oh, after he already posted a bond and technically hasn't violated, he has violated. He hasn't made any payments. That's a violation. He was ordered to pay. He was ordered to get a job. And I'm sure there were other conditions that he's violated. Judge Hesley, he keeps his cool. It's hard to ruffle his feathers, but he was ruffled. He was ruffled very much so.
Mr. Wiedeski is with us. Mr. Wiedeski, I'm here to give you to do an arraignment for you. I'm going to tell you what you're charged with, tell you what your rights are, and then we're going to set bond. With me today is Mr. Fortier from the prosecutor's office and Mr. Brown as defense counsel. The complaint against you reads as follows. It says that you did on or about May 11th, 2026 in City of Gaylord, Otsego County, that you did commit the offense of attempted assault, bodily harm less than murder / strangulation, in that you did attempt to commit the following listed offense, and in the attempt did an act towards the commission of that offense, but failed in the perpetration or were prevented in the execution. That is, that you did make an assault upon Andrew Christopher Goebel by strangulation or suffocation, contrary to the Michigan compiled laws. That is a felony offense. Mr. Fortier, help me out with the possible penalty here. This says that if the offense attempted was punishable by life for 10 years or more, it's a felony offense. I assume that the assault GBH is a 10-year offense, right?
Yes. which then makes it under
So
the
this
attempt
makes it a
statute,
5-year
makes it a
offense. All
5-year
right, so the
minimum.
maximum penalty, Mr. Wadesky, for this offense is 5 years, and it requires DNA identification profiling. In addition to that, you are charged with being a habitual offender, 4th offense, which says that you were previously convicted of 3 or more felonies or attempts to commit felonies in that on or about April the 18th of 2024, you were convicted of the offense of attempted resisting and obstructing a police officer in Otsego County District Court. On or about January the 9th of 2025, you were convicted of the offense of resisting and obstructing a police officer in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about January 9th, 2025, you were convicted of the offense of resisting and obstructing a police officer in violation, in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, because the underlying offense as a penalty of 5 years or more, this penalty is now up to life imprisonment. So you are charged with the offense of attempted assault with intent to do great bodily harm or strangulation. That has itself would have a penalty of 5 years. But because with the habitual offender on it, it becomes a life felony because the underlying offense has a penalty of 5 years or more. Do you understand the name of the charge that's been made against you?
Yes, Your Honor.
Do you understand the maximum possible penalty?
Yes, Your Honor.
Right now, you have certain rights, so I'm going to go through them with you to make sure that you understand them. You have the right to plead guilty, not guilty, or to stand mute. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. But if you enter a plea in the future, you'd be limited to asking the court for permission to appeal. Do you understand the rights that I've just given to you? Do
Yes, Your Honor.
you have any questions about any of those rights?
No, Your Honor.
Mr. Brown, have you met with Mr. Wadesky as to his right to an attorney?
Unfortunately, I have not, Your Honor. I got this rather late. When I called over to the jail, they were taking care of other matters. He has
All
been
right.
represented in the past by court-appointed attorneys. I do know that.
All right, and I'm familiar with Mr. Wadesky's current or recent issues. Mr. Wadesky, would you like a court-appointed attorney?
Yes, Your Honor.
All right. I believe that he would qualify for that. I'm going to ask Mr. Brown to get with the Mr. Gilo's office and make sure that that's true. But for now, I will appoint court-appointed counsel. Mr. Wadesky, because you've asked for an attorney and you have not had a chance to meet with that attorney yet, I'm going to enter a not guilty plea on your behalf in order to protect your rights. I'm also going to set a probable cause conference and a preliminary examination. Those are 2 court hearings that are also going to protect your rights. The first one is a chance for your lawyer and the prosecutor to meet and try to resolve the case quickly. That'll happen within the next 7 days. The preliminary examination is a requirement within 21 days. That's where the prosecutor has to come into court and bring evidence that amounts to probable cause that the crime that you've been charged with was committed by you. So we'll have those hearings set as quickly as possible to protect your rights. What we're going to do now, Mr. Wadesky, is turn to the issue of bond, and I'm going to hear from both of the lawyers on that issue. And then if you wish to make a statement as to bond, I'll hear from you as well. Mr. Fortier, your thoughts on bond?
Judge, I think the court is already somewhat familiar with the circumstances that led to Mr. Wadesky's hospitalization originally. This case kind of stems from that hospitalization. I think when you look at the totality of the circumstances, he presents not only a danger to himself just with his, the issues that he's got going on in his life, but I think also obviously a danger to the community at large, constantly fighting with police officers. Now he's fighting with the security staff at the hospital. I think it's pretty clear that he presents a pretty significant danger with his anger issues. My understanding is also that at this point, Mr. Wadesky doesn't have a stable living environment. So I think that should be something that the court should take into consideration. Any bond that gets set would also have to be cash surety only because he has the prior convictions for felonies within the last 5 years. He's also on currently on drug court probation, as the court's well aware, out of case 25-6791-FH. So I would ask that the court order the standard terms and conditions, no drugs, no alcohol, no marijuana, that he continue, if he does bond out, that he continue with his treatment programs that he's engaged in with Bear River, or any sort of additional treatment programs that he's got as a result of his recent inpatient stay, that he report via community corrections. And I would leave the issue, the amount of bond up to the court. However, I would ask that the court consider an elevated level or an elevated amount of bond, just kind of based on his prior history and the facts that led up to this.
Thank you. Mr. Brown, your comments?
Your Honor, it sounds like the court is familiar with Mr. Wadesky. The only issue that I would have that I would like to bring up is if he is in any kind of treatment, in any kind of programs, I would want to make sure that he continues those. As far as any bond amount, given the court's familiarity, I would leave that at Your Honor's discretion.
Thank you. Mr. Wadesky, I'm going to give you an opportunity to say anything that you would like me to hear at this point. I would caution you about not making any statements about the underlying facts of the charge that's been made against you, because we are recording this and I don't want that to be used against you in the future. But if there's anything else that you'd like to tell me about your living situation, about your mental health, about your ability to stay out of trouble, I'd be happy to hear those things, sir.
Yes, Your Honor. First and foremost, I want to say I'm super sorry about
Okay,
what
well,
happened.
Mr. Wadesky, you don't want to get into the facts of the case or say something.
I wasn't going to go there.
Well,
I just
he's
wanted
trying
to
to
say
say
that-
that he doesn't, hang on just a second. He's trying to say that if you try to apologize, that may be an admission of guilt. And so I understand that you feel bad about the circumstances, and I've known you through drug court for a long time now, so I can assume that. So you don't need to tell me that. And again, I'm just trying to do that to protect your criminal case. So if there's anything specific or factual that you want to let me know, that's what I'd like to hear now.
Yes. So I just got out of the treatment facility today with a great plan. I have doctor appointments lined up. I got put on new medications to help to keep me very, very stable. They kept me at the facility for a long time, longer than I've stayed at a facility ever before. I understand that Mr. Fortier would like an elevated amount of money for me to pay for bond, but if you could at all maybe think I'm going to need that money to sustain living so I can continue being stable. I would like to up maybe seeing Luke Hamlin 5 times a week just to check in more. So you guys can see me more frequently. If you would like me to go to counseling with Rosario 2 times a week as well, I'm willing to. I think I need that help, at this moment in my life. And I think that Bear River, as they have a peer recovery coach, her name's Kathy McGathy. I know that sounds like a weird name. I'm not making it up, but that is her name. And she's very, very, very good at helping in certain situations like this, that I think could be a great advocate for me, and that helped me get on the right track. This morning the plan was for me to go to the refuge so I could have a stable place for at least a couple weeks. So Nimska and my parents and we're all trying to figure out how to give myself a stable living situation. But me in here right now, I'm unable to do that. But I came out of the hospital today with a great plan, and I was picking up my car and I was going straight to the refuge. I had a whole plan ready today. I called Luke right on the way home just to check in. I was supposed to have a meeting with him at 1 o'clock. Unfortunately, I missed that. I believe he informed the police officer I was picking up my vehicle, but I I do have a plan, sir, and I'm not trying to be a danger to society. I'm not going to get into it because you told me not to, but the circumstances that happened at the hospital, that they're out of my control. That I was not just walking around Walmart looking for somebody to strangle. Like, I had a ventilator down my throat.
I understand those things. And again, I want to be careful to not have you talk about the facts of this particular case because I don't want it to be used against you later. So I understand what you're telling me, that there was in your mind a reason to do what you did, and I'll leave it at that. All right. Yep. Anything else any other facts that you want me to be aware of, sir?
No, I just appreciate you all seeing me in a very timely manner today.
All right. Thank you, Mr. Wiedeski. Mr.
Jeff,
Wiedeski, go ahead.
Sorry, I was just going to suggest one more thing. Mr. Wiedeski kind of hinted at it. I think with us all knowing his history, if he does bond out, today, over the weekend, whatever, I would ask that he meet with Mr. Hamlin as soon as possible.
I'd go there right here. I'd go right now.
Might be good for him too if he checks in with Rosaria like right away upon any discharge from the jail as well.
And I'd make a phone call to her on the walk to Luke. My car's at the hospital, so I would be walking that way to Luke. Right now, I can make that phone call to Rosario as soon as I get out of here.
Thank you, Mr. Wiedeski. All right. The court has alluded to the fact that Mr. Wiedeski and I are acquainted through a drug court. Mr. Wiedeski, I believe, is your phase 3 in that drug court program. Mr. Wiedeski, is that correct?
Yes, Your Honor. I'm looking.
So you've been in drug court for about a year and a half now, give or take a little bit.
Since November 22nd of 24.
Yep. So, and I came on the bench in January of 25. So it's been almost a year and a half that we've had regular contact every couple of weeks during drug court. I've talked to Mr. Hamlin repeatedly about Mr. Wiedeski and some of the difficulties that he's had to go through. I'm aware of his previous mental health concerns that came up during drug court, sobriety court, and required him to have some inpatient treatment a few months ago, much like his current inpatient treatment that he went through preceding these charges, or as a result of these charges. And so I'm very familiar with his history and his involvement in our local community from those things as well. I say that by way of making sure that everybody knows that I'm aware of his concerns and his issues. Mr. Wiedeski in this particular case is charged with a very serious assaultive or attempt at an assaultive crime, and his habitual offender notice makes the likelihood of, if not long-term jail, likely of prison opportunity to go here. So these are very serious charges. His current living circumstance has changed. I'm aware of what that was through his sobriety court time, and he's not able to return to the house that he had been in as a result of that. So he would have to be in a something like the refuge, which would be a very temporary existence, and would not provide Mr. Wiedeski with the structure in which he does best. In addition to that, Mr. Wiedeski has had difficulties in the past taking his medications as prescribed and not abusing them, or taking them more on occasion and not taking them on occasion, which tends to make his moods and his circumstances go up and down somewhat, making it somewhat more difficult for him to be compliant with the requirements of law because of the amounts of chemicals within his system on occasion. And we've struggled with that with him over the course of his sobriety court experience. My concern at the moment not only is for the community, given his assaultive behavior as indicated in the complaint made against him, but because he's so recently out of treatment, And I believe that he needs to be in a very structured environment to make sure that the medications that he's on continue to be within him. And he thrives best in a very structured environment. And I don't believe he would have that available to him, even with the current assistance that he receives through the sobriety court. Mr. Hamlin cannot see Mr. Wadesky but more than a few minutes each day. Ms. Rosaria, his counselor, can only be with him a few half hour or an hour on a weekly basis at best, and she's not readily available because she has other people that she deals with on an as needed basis. So upon discharge, if he were to be discharged into the community, I don't believe that he would be, excuse me, I do believe that he would be a danger to himself and others given the lack of stability. All of that to say this, I believe that a high bond is necessary to make sure that the community is safe. And quite frankly, more importantly to me at the moment, is that Mr. Wadesky himself would remain safe. He has been on suicide watch in the past, and I don't want him to have to return to that just because he was let out and left to his own devices at this time. So I'm going to set a bond in the amount of $50,000. That will be cash or surety only. He does not qualify for a lesser bond, given the fact that he's on probation with the sobriety court, and the fact that he has committed the felonies that were put on the record within the last couple of years, within the last 5 years anyway. And so he does not qualify for a lesser bond under those circumstances. If he does, or if he is able to post $50,000 cash or surety, he must personally appear for any scheduled court date, must abide by any judgment entered by this court. He may not leave the state of Michigan without the permission of the court, may not commit any crime while on release, must immediately notify the court in writing of any change of address or telephone number, may not use alcohol, marijuana, or illegal controlled substances, and may only use prescribed substances as prescribed. That means no overdosing. Must participate in a specified treatment program for any physical, mental condition, including substance abuse. That would include all requirements of the sobriety court, any mental health requirements. May not have any contact with the victim. This is Andrew Goebel.
Judge, can we put somewhat of a qualifier on that? Mr. Goebel is a security officer at the hospital. So, I mean, in the event that Mr. Wadesky has to go to the hospital, I think, any sort of like brief incidental contact between the two of them shouldn't be the main concern.
So I'll put down except as to employment requirements. So that if Mr. Goebel has contact or sees him at the hospital, that's not a violation on Mr. Wadesky's part. If he's going to the hospital for a proper reason, or is at the emergency room, that would not be a violation. However, if Mr. Wadesky is not properly at the hospital, that would not be a proper employment reason for Mr. Goebel to have contact with him. There must be no assaultive, harassing, intimidating, beating, wounding, or threatening Mr. Goebel. So even if he is there appropriately at the hospital, there no further contact that way. No possession or purchase of a firearm or other dangerous weapon. Must contact community corrections. That's the agency that monitors people that are on bond for felony cases. The jail has the contact information for that upon any release. Mr. Fortier, would you ask for any other requirements of bond?
No, Your Honor. I think what's been put in place, along with the fact that he's still currently on drug court probation, are sufficient.
Mr. Brown, any input?
No, Your Honor, thank you.
Oh, I do want to add one more thing. If he is released, must meet with sobriety court probation officer Hamlin, counselor, and that must be done within 8 hours of release, and must follow all recommendations. All right, that's all for today then. Thank you very much.
Thank you.
Mr. Wadesky.
right here. Yep.
Afternoon, may I have your name, please?
Sorry,
Your name.
Edward
May I have
Manso.
your name?
Edward Manso.
Good afternoon, Mr. Manso. We are on the record in case numbers 267648 SM and 267630 SM. You're appearing for arraignment purposes in these cases. You're appearing with Ms. Mistley, the defense attorney available through the Indigent Defense Council, here to assist you. Ms. Mistley, in these cases, did you have opportunity to review allegations on the complaints, nature of the offenses, and possible maximum penalties with Mr. Manso?
I did, and we will waive formal readings of each of those misdemeanor complaints, enter pleas of not guilty, and request the assignment of counsel.
So in order to complete a petition for court-appointed attorney, I need to place you under oath and ask you some questions. Would you please raise your right hand? And you swear that the information you're about to give me will be the truth to the best of your knowledge?
I do.
Thank you, and you're welcome to lower your hand. Mr. Manso, what is your phone number?
I don't have one.
What is your mailing address?
You can use 6th Street, but I don't collect it very often.
Where is it that you're currently residing?
Safe Harbor or the street?
Are you working?
No, ma'am.
Do you receive any source of income or assistance?
No,
Do you own a vehicle?
no,
Do you have any money in a checking account or savings account? Any cash on hand?
none.
So I will appoint an attorney to assist you in each of these cases. The next step is a pretrial conference, and the pretrial conference will be scheduled for June 11th at 9:30 a.m.
Okay.
Ms. Lee, is there information you'd like me to know regarding bond?
Well, we would request a release on PR bond on these non-serious misdemeanor complaints. It's my understanding that Mr. Manso has no other cases pending at this time, and nor is he on probation. That's all I have. Other than Mr. Manso, if you are released from jail, you need to check your mail at that 6th Street address at least twice a week, preferably 3 times a week. Since you have
All
no
right.
phone, your attorney, that's the only way they'll be able to try and reach you.
Understood. I'm sorry.
That's all right. Just make sure you check it.
I will.
So, Mr. Manso, although there aren't any other cases, you are being held on a contempt charge. And so in each of these cases, your bond is going to be a $1,500 10% bond. Conditions on the bond are in case number 7630 that you'll not return to East Bay Flats. You'll have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case. In each of the cases, it's also a condition of your bond that you shall not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You will provide a list of your current prescriptions to the district court clerk. You will submit to daily PBTs proving you're not drinking. You would also submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel. You may not refuse. You may not enter a bar, casino, or any place that serves alcohol by the glass. And again, you'll have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of the case. So with regard to the contempt charge, you are being held for a failure to appear on a subpoena for a preliminary examination. The court is going to assign an attorney for you in these 2 cases. You're welcome to speak with the attorney with regard to the contempt proceeding as well, but you will be remanded to jail until the time that you are able to see Judge Stepka, either with a plea or a hearing.
And do we know when that would be, Your Honor? And if it's not today, then I'd like to be heard with regard to bond on that as well. I'm told that
It is not today. Judge Stepka is not here. So go ahead, ma'am.
Okay, well, so Mr. Manso tells me he was not served with a subpoena. He did not know he was supposed to appear in court anywhere for anything yesterday. I've checked, what I can check from my computer, the court file. I'm not seeing that a subpoena was filed with the court, much less, and more importantly, for our purposes, a proof of service of that subpoena. It seems like a utter lack of due process to hold someone in jail on a contempt charge when there's been no proof of service.
So I understand your concern, but getting the information only from Mr. Manso might not be the whole picture. Sometimes people begin, I'm not saying in your case, Mr. Manso, but sometimes people are intoxicated to the extent that they cannot remember. And so whereas service may have been held, he might not have remembered that he was served.
Well, so does the court have a proof of service in the court file? Hold on, Mr. Manso. Just for the record, is there a proof of service that's been filed with the court or testimony by someone who served him?
I do not see that. The bench warrant was issued yesterday by Judge Stepka, and I don't know what information was provided to Judge Stepka at that time. My guess is Judge Stepka would have asked if there was proper service before issuing. Where is it? I'm sorry, Charlotte just sent me a message that we do have a proof of service.
No, I said, do we?
Oh, sorry. In any event, Judge Stepka signed that warrant. So my guess is again that there was information provided to the judge that Mr. Manso had been properly served or noticed for the preliminary examination. So I am going to remand him.
Well, just so our objection is on the record, and Mr. Manso, make sure you discuss that issue with whichever attorney is assigned to you in the other matters. Okay?
Okay. Thank you.
Good luck to you.
Thank you.
Thank you.
Right. It would, so tell her it would be in the.
The next matter I have is Alexander Gott. We helped Mr. Gott with the paperwork. He will be proceeding pro se as he is currently a conflict for our office, but as these are arraignments, he is asking to enter a guilty plea at this time.
Good morning, sir.
Morning.
What is your name?
Alexander Gott.
Mr. Gott, what's your birthday?
April 24, 2002.
Thank you. Mr. Gott, Mr. Lockhart from the Public Defender's Office has told this court that you do not currently have an attorney because you are a conflict of interest with that office, so they cannot represent you ethically. You are entitled to a free public defender if you qualify financially. It is important to have legal representation going forward. You do have several criminal charges against you. Would you like to be screened for a public defender?
Yeah.
All right. Mr. Gott, give me one moment as I get into the file here.
What is I see a recommended jail sentence here. Is Mr. Gott held to serve that as of now?
Him currently serving, you mean with the 20 days being asked for?
Yes.
He will be starting to serve that today. He's been held on just these 3 charges at this point.
I see. And is there a note for any credit for time having previously been served on this controlled substances possession charge?
I don't think he's been held on this charge before. We're at arraignment. He's had FTAs, but I don't think he's been booked in on these.
Okay. Mr. Gott.
Yeah.
We're at a bit of a sticky issue here because you appear before this court and I see a guilty plea statement before me. In order to allow you to proceed with that guilty plea and for this court to accept it, we need to establish that you are making that plea knowingly, intelligently, and voluntarily. And how we customarily do that is by asking your court-appointed lawyer to tell the court that they have gone over this plea form with you, and if you had any questions, and if you understood what you were doing and why. So, while you do have the right, well, let me put it to you this way, Mr. Gott. If you are held to serve on this matter, you will, according to this recommendation, receive a 20-day jail sentence.
Yeah.
Because you do not have an attorney with you to represent you today, I am trying to find a way forward to allow you to do what I think you propose to do, which is plead guilty, but at the same time to make sure that all of your rights are being upheld. If Mr. Gott be inside his speedy arraignment, if that could be set over for him to be screened for counsel, I heard that he wants that rather than to represent himself pro se. To be clear, Mr. Gott, I heard that you wish to be screened to be appointed a public defender. Is that correct? Okay.
Yep.
I am hesitant to accept Mr. Gott's guilty plea without a lawyer present to tell me that he's okay to do it. Does counsel have any suggestions here? I'm concerned that Mr. Gott is not held on this charge.
Well, he's held on these charges, so then we'll just have to enter not guilty and then address bail. On 2 of them, the city has a motion to dismiss the 3rd because it's going to be filed as a felony.
I did
charge.
see that.
So,
do we? He's held in custody.
Yeah, I mean, we would address release conditions here if you're going to enter a not guilty plea for him.
Yeah, I think
I mean, we're going to ask that he be held, but
yeah, Mr. Gott.
And he'll be getting credit towards that 20-day sentence too, right? If he's held in bail.
This was my question. Yeah, I wanted to make sure that.
Yeah, he's not. Yeah,
we weren't going to restart the clock for Mr. Gott if we came back next week or.
Yeah,
Mr. Gott,
yeah.
I want to give you time to speak with a lawyer before you come back before this court and enter this plea. Counsel for the city has indicated that you have at least one charge that is being dismissed in the Bellingham Municipal Court, and it may very well be refiled in the Superior Court. That being said, I want to make sure that you've been advised about how these guilty pleas, if you enter them, may or may not complicate what happens down the line for you. So what I'm going to do today is I'm going to enter a not guilty plea on your behalf to the charge of knowingly possessing a controlled substance. And I think it will be the next matter of business to talk about what will happen until your next court appearance here. Mr. Gott, for the record, you have the right to be represented by an attorney of your own choosing at all proceedings. If after you're screened it's determined you can't afford an attorney, we will appoint one to you. If you don't have an attorney at arraignment, you do not need to waive your right to an attorney at any later proceeding. You're presumed innocent of any charge until the charge is proven beyond a reasonable doubt. You have a right to a speedy trial within 60 days if you're held in jail, within 90 days if you are out of jail. You have a constitutional right to a jury trial unless you specifically give up that right. You have the right to see, hear, and question all the witnesses who the city brings to testify against you. Likewise, you have the right to call witnesses on your own behalf. You may have this court subpoena witnesses to appear and testify at no expense to you. You have the right to testify on your own behalf. You also have the right to remain silent and to refuse to testify or present evidence against yourself, and your silence cannot be used against you. If you feel you cannot have a fair trial because of the bias or prejudice of a judge, you have the right to ask for a different one with 10 days of notice. You have the right to appeal the finding of guilty following a conviction at trial. If you are not a U.S. citizen, a conviction of a crime may result in deportation or exclusion from admission to the USA or denial of naturalization. You have the right to consult with an immigration attorney prior to being arraigned. If you plead guilty, you give up or waive all of those rights listed, that I have just read, except for the right to be represented by a lawyer. Do you understand all of those rights, Mr. Gott? Was that a yes, sir?
What?
Yeah, speak into the microphone so we can put you on the record. Mr. Gott?
Yeah.
Okay, thank you. I'm going to call this arraignment, entered not guilty plea. We're going to have a readiness or...
We just set a pretrial after that and another pretrial date. The clerk can give you that. And the city will do up to 2 housekeeping matters. One is bail on those 2 cases, and then the city does have a motion to dismiss the possession of stolen property, as that will be refiled in Superior Court. There is an order, a motion, I believe, or an order of dismissal, I should say, in court. Yeah.
Let me do that first. Council, comments on the city's motion to dismiss?
No objection to that, Your Honor.
Okay. Mr. Gott, the City of Bellingham's prosecutor's office is asking this court to dismiss the charge of possession of stolen property in the 3rd degree. According to this motion, the officer providing that referral will be giving that case to the Walker County Prosecutor's Office for being charged as a felony, so look forward to that. I'll grant that motion. I think it needs your signature too, Mr. Lockhart.
For the dismissal, Your Honor?
For the order. All right, and as for the 2 remaining charges, we would discuss the release conditions. Yep. City have recommendations?
Yes, Your Honor. So the defendant had FTA'd on both previously, so warrants were issued. He does have 3 prior convictions. I think bail is set pretty low, is $500 bondable, appearance bond on each. I think with a $100 warrant fee, so they're showing us $600 each. The city's fine with just maintaining that at this point, and they'll be getting credit. These would be 4th and 5th offenses, so yeah.
It was 500. Or 500 each.
Yeah, I think that's what it said, at 500 appearance, yeah. And $50 cash alternative is fine with the city on both.
Okay. Council.
And Your Honor, Mr. Gott indicated to co-counsel that he is currently homeless and not in a position to be able to post any amount of bail.
Thank you, Council. Understood that you have limited means to pay, Mr. Gott. I'm still going to be asking you to be held on $500 cash or bond in these 2 matters of knowing possession of a controlled substance. The upshot of that is that you will be held and serving time for the charge if you do follow through on that guilty plea at a later date. You'll receive credit for this time. This was only arraignment on 1. Do I have that correct? Oh, no, I see 2. Okay. I believe he's already appointed. Oh, wait, no. Mr. Lockhart, previously having been appointed on the, or no, actually, I don't think we have been.
He was found eligible for a public defender in the past, and then we've conflicted it out. I don't think his financial situation has changed in the last few months. Mr. Gott is, typically he's been unhoused and unable to, doesn't receive any benefits other than I think EBT, so I don't think that's changed. But if the court sends the referral, we'll get it sent out to conflict counsel.
That is my intent. And what do I? Defendant having previously found indigent, the court finds him eligible for appointed counsel. Defendant is in conflict with North County Public Defense. So, Mr. Gott, what that means is that we will send a referral to the conflict counsel that is available to us and get you appointed counsel. It should be in touch with you directly. I am going to set the next pretrial date 2 weeks from now, on the 8th of, approximately 2 weeks from now, on the 8th of June at 8:30 a.m. in this court, by which time you will have earned 2 more weeks of credit, and you should be out or very close to time served if you do wish to go through with that guilty plea I saw earlier today. I don't want to take that onto the record today without being quite sure that you've been advised of your legal rights and what it means to waive them. Okay?
Okay.
Okay, Mr. Gott, that shall be the order of the court. I've signed that order and out of that document. Thank you, Mr. Gott. I'll get a copy of that order, I assume.
The guy's really lucky that the judge is looking out for him, because the judge could have just taken the guilty plea and charged him, sentenced him right there. But no, not without counsel, especially since he said he wanted counsel. He wanted counsel, but he also wanted to get it behind him and plead guilty right away. Judge is like, that doesn't exactly work together.
What date did we set the pretrial, Your Honor?
Pretrial would be June 8th at 1:30.
Okay, thank you.
And, Mr. Gott, it was July. Mr. Gott, if by chance you bail out or are released before that June 8th date, we have set an out of custody pretrial date, which is July 20th in this court. As we've discussed, we assume or we foresee that you will still be here in jail on the 8th of June. We can go through that proceeding, but if for any reason you are not there on the 8th, we'll strike that hearing and see you in July.
All right.
All right, thank you, Mr. Gott.
Thank you.
And Your Honor, the next matter I have is Cottrell Trott.
Call the matter of Cottrell Trott, cause number 5A308207. Good morning, sir.
Good morning.
What is your name?
What? Trott, Your Honor.
And what is your date of birth, Mr. Trott?
10/7/1989.
Thank you. Judge shows us as here before the court for an alleged probation violation. Is that correct? On May 21st, this court received priority hold bench warrant, or issued, I should say, a priority hold bench warrant for failure to appear at a hearing. That was yesterday. What are we doing today, counsel? Or probation?
Thank you, Your Honor. It looks like the recommendation is a revocation and an 85-day sanction.
I heard probation recommends revocation and 5 days jail sanction.
85.
85 days
Yes.
jail sanction.
Yes. And Your Honor, I'm not sure if you'd like probation to provide a little bit more information, but it does
I
look
was
like.
about to ask probation, and what do we have in support of that ask?
So it looks like the issue is that it's been I think even over a year, and it looks like it was active and then warrant, active and warrant. So there hasn't been any progress made on probation. When I believe it was the domestic violence evaluation and treatment that was the requirement, and that has not been completed.
Is there any proof ever provided? I should ask counsel, actually. Yep. Mr. Lockhart, comments on this?
And Mr. Trott has indicated that he has completed the evaluation. He would be able to provide that to probation. What I think with the amount of time that's being asked for, I think probation's taking a little bit of that into context as well. Based on the number of priors that Mr. Trott has, I think probation could be asking for up to 150 days. So the 85 is quite a significant reduction based on probably a multitude of factors there. But as of right now, Mr. Trott certainly would like to remain on, but I do understand that probation's perspective here that, it's been over a year, it's been in and out of warrant status. I think the 85 days is reasonable considering the alternative of a much higher request. That would be the standard request in this court as well. So at this point, we're just asking the court to follow the recommendation and then ask for any jail alternatives that he would be eligible for. He'll need to screen in for those, but if the court allows for that, to whatever he's eligible for.
Thank you, counsel. So, Mr. Trott, your attorney, Mr. Lockhart, has indicated, if I understand correctly, that the probation recommendation, which is to revoke you from probation and impose 85 days jail, is agreed. He had some comments as to the appropriateness of that. Do you have anything to say, sir?
I believe 85 days is a bit high, but I understand.
Give me one moment to look at the jail roster here. And I do know appear to be matters still pending in Superior Court.
Considering the matter has been dropped in Superior Court, and it seems to be like touch and go with municipal and district court, honestly, and it's landing in Ferndale's backyard. It's just been going back and forth, but the matter has been dropped. The order, no contact order, has been dropped from Superior Court, and I have done my the DVET lines, and I provided it for probation. I think the second to last time I showed up for my court date. So I do believe 85 days is a bit high, but I would like to get this done as well.
Okay, Mr. Trott. I will tell you from a review of what appears available to this court in the public record that indeed there are a couple of pending matters in the other courts that you should pay attention to. You're correct. The matter from Ferndale does appear to be still open, as well as the Superior Court matter, and there are several active no contact orders, which I would defer to your attorneys in those respective cases to explain the terms of to you. It is not this court's job to explain to you orders from other courts. However, I will say that currently there is an active order out of this court. I'll take a second to review it. The order was filed last year on March 17th, and it remains in effect. It prohibits Cottrell Trott from having any contact with Rebecca Trott. And it remains in effect, Mr. Trott. I'm going to follow the party's recommendations. I'm going to impose 85 days jail, less time served, and I will revoke probation supervision at this time. It has been over a year by now, and probation's remarks do appear to be reflected in the court's record, several warrants, and I don't see any progress that I would make a note of here, so I will impose that 85 days revoke probation. Mr. Trott, you will receive credit for any time you have served on this matter against that time. I would just advise you to stay in contact with your attorneys in your other pending matters to make sure you don't miss any dates and get a new warrant.
Understood.
So we're revoking no future probation review necessary at this time.
Thank you, Your Honor.
Thank you, Your Honor.
We run, it doesn't matter if I run consecutively or concurrently at this time. It's not held on anything else.
I'm sorry?
I was asking Matt Clerk about how to run the time, but we'll Let's see if this works. Mr. Trout, I am going to authorize that you can serve any amount of those 85 days of this sanction on jail alternatives if you are found to be eligible. If memory serves, and that is an application for jail alternatives that you can make from inside the jail.
Thank you, Your Honor.
Submit a probation revoked 85 days jail, opposed jail alternatives as eligible. And that shall be the order of the court. Thank you, Mr. Trout.
Thank you, Your Honor.
Next matter before the court is Selena Wergow and Jason Lambert. That's file 12-14709-DC. I do see Mr. Lambert is here. Do we have Ms. Wergow with us?
We do not, Your Honor.
All right. I believe this is a objection to referee's recommended order filed by Mr. Lambert. Mr. Lambert, you want to tell me what it is that you object to and why?
Well, it's like a 600% increase right off the bat, but also the biggest thing is you know, it was filed a few years ago. We switched over to Florida, so I was making payments in Florida, but because of the arrearage, she filed with the state attorney general, and I'm still on probation trying to get that paid off. An increase to you know, $1,600 a month, and in fact, it said it went back to March, so you know I owed like another $4,000 to get that paid off by the end of this month. That jumped up to $8,000. She did say we were supposed to have that referee hearing back in February, I believe it was. And when we went to that, she was present with that, and you know, she was in agreement to have a conversation about a lesser amount. But the referee at that time said that he didn't have time to hear us, and he said if I want to object to it, then I have to file again, which is what I'm doing now. So, you know, I've got the paperwork here in front of me with the calculations, and you know, looking at the end of the day, you know, with what they're wanting me to give and what I mean, that puts her monthly adjusted income at $1,000 over mine. So, you know, I mean, I've been doing what I can in the last few years to make more and more money to get this all covered, because I had 3 years to pay off, you know, $20-something thousand, which that's a different story. But, you know, but every time I make more now I got to get hit with it. So I, you know, but the more I make, the farther behind I get on it.
All right, Mr. Lambert, simply saying that you disagree with the number doesn't give me a legal basis for determining that the number is wrong. What information or what documentation do you have that shows that the numbers used by the friend of the court were inaccurate or were wrong?
I guess I can't say that they're inaccurate or wrong, but if at the end of the day, you know, it puts my income at $1,000 a month less than hers, I mean, that seems like there's a miscalculation somewhere. I mean, I don't know. I don't do the calculations. I don't know how it's done. But like I said, I mean, you know, she was in agreement to having a conversation about it, and we weren't able to during the mediation, which is why we're here again today.
Well, the referee is not a mediator. That's not his job, and it's not his position to mediate and to determine whether or not the parties reach an agreement. And even if the parties reach an agreement, typically that's not a reason necessarily for changing the child support guidelines in the formula. So if you guys had an agreement, we could have looked at it and said, does that meet the guidelines, or is there a reason to depart from the guidelines? But you guys didn't reach it. So the referee is not required to conduct a mediation. So
under the guideline, I'm sorry.
Go ahead.
I was going to say, under the guidelines of the state order with the probation, I'm not allowed to have contact with her. So like, I'm not allowed, I can't reach out to her and have a conversation.
I can't help that. I can't change that. So all I can tell you is the referee's not required to do what you're asking, which was mediate, which is give you a chance to negotiate with each other in court. That's not what he's there for. That's not the process. So having no mediation ability, unless the parties are able to, and it sounds like you can't for other reasons. The only other question before me is any of the information that the friend of the court used to arrive at these numbers Was it an inaccurate number, or was it inappropriately used? And so far, I've not heard anything other than you dislike the way it turned out. And I get that all the time, so I understand what you're saying, but I can't change that process unless there's an inaccurate number. The guidelines.
Sorry.
Let me just finish for just a second. The guidelines for the state of Michigan have been established by federal rule and by state rule. And it's gone through a vetting process, and the courts are told that we're required to use the process, that the guidelines, the computer program for that, unless there is a legitimate reason to depart from it, a legal reason to depart, not just I disagree with this increase or that sort of thing. So I've got to have a legitimate error, or I've got to have a reason to depart from what the law says I'm supposed to follow. So do you have any of those reasons?
I don't know. I can't say that the calculation. I just think a 600% increase overnight. I mean, that's catastrophic. I just signed a new lease. I can't afford my bills at that. That leaves me under $4,000 a month to make my rent and my payments and provide for my house. It seems absurd to me that, because I finally got to where I can make these payments and get this probation paid off, that now I'm going to get set back. I mean, they gave me 3 felony counts. If I get it paid off, it's a misdemeanor count. I've got no avenue to pay that off. That's $1,600 a month. It just seems absurd. I mean, I wouldn't, just to make the adjustment while I'm still under the state probation and all that. But that's supposed to.
I understand exactly what you're telling me, Mr. Lambert. I believe me, I do. But I don't see any legal basis for departing from what the guidelines requirements are, simply because it creates a hardship for one party or the other. The numbers of the income levels look appropriate to me that were used. I'm looking at the referee's the friend of the court's recommended dollar amounts. The deductions appear to be appropriate. They've given the proper net income. They've laid out all of the dollar amounts for the base support calculation, the healthcare allocations, ordinary medical, childcare expenses. All of that appears to be exactly the way that the program is designed to run. And that's why they do it that way. They lay it all out in detail. In case anybody has an objection, they can say, this is what we put down for this number. This is what we put down for that number. And as long as those dollar amounts are fed into the computer system correctly, I'm supposed to use what comes out of the computer system, because that's been vetted by the federal government and the state government as to that's how we want to run our child support system. Any other information that you want me to know?
No, like I said, just looking at the calculation, I mean, that drops my monthly net down to 3,209 and hers up to 4,266. How do I live on 3,209? I mean, this is the first time in my life that I've made enough to cover this child support, which, I've fought with this for years. And every time I've been told you need to make more money. Now I make more money, and I might as well go back to what I was doing a year ago. At the end of the day, I had more money in my pocket. I'm making $50 an hour now, minus $12 an hour in taxes and stuff, and taking now another $10, $11 an hour to give over to her. It leaves me nothing here. I've got the same requirements here. It's just the calculations. I don't know. I guess. I mean, if that's what it is, then that's what it is. But why? I don't understand why the system is designed to just keep kicking me down.
It leaves you 38 grand after your child support is what it leaves you. Are you telling me you can't survive on that? 38 grand a year?
Well, I mean, rent is 24,000 a year. I've got 2 kids. I've got 11-year-old twins here.
Why are you paying $2,000 a month for your rent?
Because that's what it costs.
Where you live?
Punta Gorda, Florida. Been here for 11 years.
There has got to be a cheaper place to live than that.
If I would like to move into a trailer house in Arcadia, but Selena doesn't live in a trailer house out in Vanderbilt. So I mean, that's not a fair assessment. I'm
You're the
paying
one who
less now
chose-
in rent than I was 3 years ago.
You're the one who chose to live in Punta Gorda. I can't change. You're asking me to change numbers based on your decision about where to live and what to spend your money on.
How much is rent in Gaylord, Michigan?
I live in a 3,000 square foot house and I pay $1,200 a month to the bank for my mortgage.
That's a mortgage, sir. I can't get a mortgage because I have X amount in child support and my income's not there.
I'm just telling you, I live in a very nice house in a very nice subdivision because I chose to live in Gaylord, Michigan.
That's a
You
mortgage,
have the
sir.
right
That's
to
not
live.
rent.
You have the right to live wherever you want to live, but you made that choice. Nobody else did. So I'm not going to change child support because you decided to live in an expensive area.
Or, I mean, yeah, I don't. I guess I mean, I paid rent in Gaylord in 1998. It was $1,200. That was 20 years ago. I would assume it's gone up since then.
All I'm saying to you is you got 38 grand. Spend it how you want, but you got 38 grand to live on. There's lots of families in the world that live on less.
And now she's got 60. So that's great.
Mr. Lambert, I get it that you don't like it, but I can't fix it just simply because you don't like it.
She doesn't have 60. Your children have the support that they need for clothes, food, shelter, schooling, all of the things that it takes to raise the children that you helped create. It's not like she has 60 grand and the kids have nothing. You're looking at it all wrong, buddy, and maybe that's part of your problem. You're being a selfish man-child.
I'm trying to get state probation paid off, and I'm getting kicked. Like can't even wait till the end of that. I don't understand this. It's absolutely absurd.
It's ongoing child support. Your children don't have less bills because you have more bills.
So she's got a 600% increase since this time last year.
She doesn't get any of it. She gets to pay the kids' bills. That's what it's for. It's not for her. It's for the kids. If you don't like that, that's too bad. That's the way the world works. You bring kids into the world, you pay for them.
Okay, yes, I do. And I don't get to see them, and
then file a motion to see your kids for more parenting time. Nobody's stopping you from doing that.
Luann Dean fought her for years.
Your objection is denied. Thank you very much, sir. That's all for today.
Yeah, of course it is. Bye.
Have a good day. Next matter is Nigel Ingersoll and Cassandra Ingersoll. We also have a companion case of Nigel Ingersoll and Krista Carnahan. The Nigel and Cassandra case is 23-19438-DM. The Nigel and Krista case is 15-15991-DM. I do see Nigel is with us. Krista is with us. I do not see Cassandra yet. Is she on?
She is on.
All right. These are Mr. Ingersoll's objections to the child support recommendations in both of these files. Mr. Ingersoll, what is it that you are objecting to and why?
Your Honor, I am objecting to the support amount because I think it's a little steep. Now, I filed that motion a little ways back. We just had court the other day, and at the time of me filing the motion, I had not gotten to see my son, and I had definitely disagreed with having to pay her if she was just holding him hostage. Now that there's an order and there's some parenting time established, I think I'd rather just have a couple questions instead of an objection.
All right.
The first question, if I may proceed, Your Honor.
Go ahead.
So I just want to know that if I make the child support payment that's recommended, do the mothers of my children get that in full, or is the state somewhere somehow going to find a clever way to try to dip their hands in what should go to my kids when there's not a vested financial interest from the state of Michigan on either case. Neither one is out of state and not drawing assistance, and the other one is also not drawing assistance. So if there's no state help, I just want to make sure that the state's going to stay in its lane and pay these women the money that my children deserve instead of funneling it into their pockets for pressing a couple buttons.
Sir, to put it into perspective, I don't know about Michigan, but I know in Wisconsin, it was $25 per year for the state to manage the child support. $25 per year. Yes, there is a small fee because they're doing a lot of work to ensure that the money goes to the children. But it sounds like you have other issues.
As far as I know, Mr. Ingersoll, the money that you pay for child support goes to the children for child support.
All right. All right, that's all I got. Actually, I do have one more question. So I am expecting another child soon, and I was wondering what the time window is for me to have this re-looked at again. I know that with another child, it should be split a little. While I do not disagree that I should have to pay some support, I just want to make sure that I can make my ends meet and fulfill my obligation, because fresh out of vacation land, I'm really just kind of getting on my feet again, and I'm really starting to reestablish myself in a relationship with my children, and I just don't want to drop the ball and fumble your recommendation and end up in jail with no license. And
Vacation land, meaning prison. He just got out of prison.
The answer to your question is, once the new child has been born, if you would take a copy of the birth certificate to the friend of the court, they can then conduct a review of the child support and give you credit for another child in your household, and see if that changes to any degree the child support that is owed to the other children that you already have. The friend of the court is they do that kind of review on a regular basis, and I'm sure that they would be happy to do that again in this case once the child has been born.
all right, and then I guess one more question, and I'll let you get going. Is there going to be a retroactive, like some surprise number that's going to throw me right out of my Jordans? I don't know how this whole thing works. I was gone for a little while, and like there's been a recommendation, but it hasn't been established. I'm just wondering if you guys are gonna throw a surprise $5,000-$10,000 fee at me, like, oh, by the way, you also owe this, or if we can start fresh, so don't end up in the hole.
Okay. Mr. Ingersoll, there is on each of the recommendations an effective date. It's on the first page of each of the recommendations. It indicates the effective date in one, which is the one involving Krista. The effective date of this recommendation is December the 1st of 2025. And the one involving Cassandra is August 22nd of 2025. I'm assuming that's when the request was made for each of those reviews to be made. So those would be effective as of those dates, so that they would go back to those dates and begin the calculation then. So there's always, because we have to start a process and then work it through, there's always a little bit of time where that does accrue, quote, an arrearage. But nothing is done as far as enforcement goes as to that arrearage, as long as you're making your payments on a regular basis. So there's no adverse action against you, and that's that arrearage is repaid over time as you go on and continue to make your payments. Does that answer your question?
It does. The only thing I am confused about is, so you said the case with my daughter is backdated to the day I got out of prison. Like, I wasn't working. I was at home with the kid. Like, I didn't start working until a few months after I got out. You're really holding me accountable?
It starts when you get out. Not the kids' bills don't go away simply because you haven't got a job yet. They still have bills, so it goes from the date that you're out, or the date that the other party asks for it. Ms. Cassandra, I'll get to your question in just a minute. Any other questions that you have, Mr. Ingersoll?
Yeah, what about the times that I wasn't allowed, where both of these women filed PPOs on me and I wasn't allowed to see my children? Like, you really don't think that's kidnapping, hostage? Like, since they decided they wanted to take that route, I don't think I should have to eat that payment when I wasn't getting to see my children against
Mr.
my will.
Ingersoll, I apologize for interrupting. There is not a direct correlation between, there's no pay to see your kids. That's not how this works. You pay because the kids have, you pay because the kids have bills. If you believe that your parenting time has been violated, you have the right to take that issue, parenting time, to the friend of the court and ask for makeup parenting time if you believe that there's been a problem with it. But there is no direct correlation between I didn't get my parenting time, so therefore I don't have to make my child support payments. That is not a legal right. Any other questions that you have, Mr. Ingersoll?
Yeah, what's the total I owe you guys? Like, should I call?
You'll have to talk to your caseworker about that. I don't have access to that information in front of me right now.
All right. Okay, I'm done.
All right. Cassandra, did you have a question for me?
Oh, can you hear me?
I can.
Okay, cool. So I'm just curious, since all of this has gone down, I've lived in Tennessee now for just over a year and a half, and in that year and a half, I've paid $12,000 in childcare, like daycare expenses in that year and a half, and I have proof of all of that. Is there a way I can try to get him to help me pay some of that? Like, I pay $200 a week for my daughter to go to daycare, and I've paid $200 a week for a very long time, and it's a lot of money.
You can file a request with the friend of the court to have that addressed or added to child support. I'm not telling you whether or not it's going to be granted, but you have the right to request that. Ms. Kraus has the file, both of these files. So if you would talk to her and see what documentation that she would require in order to move forward with determining whether that would be allowed. And then you can, if she doesn't allow it, you can object to that, or Mr. Ingersoll would have the right to object to it as well. And that would be determined at a hearing in front of me after Ms. Kraus has a chance to see everything and make a recommendation. Ms. Kraus, is there anything else that you would ask about for that particular request?
She would just need to, because she is in another state, she would just need to submit that information indicating that she would like a review. That should be under a change in circumstances. The only thing it wouldn't do based on a review option is retroactive to the date. So her other option would be filing a motion to have the court address that date.
All right. So Ms. Ingersoll, basically what all that means is get the paperwork from Ms. Kraus, submit what you want, talk with her about what can and can't be done. And then if you disagree with that, we'll have a hearing on it. Just like if Mr. Ingersoll disagrees, we would have a hearing on it. Okay?
Yes, sir. Understood. Thank you.
All right. That's all for today then. Thank you all very much.
Thank you.
The objection in both files will be denied for the reasons stated on the record.
That was fun. Yes, I did. I made it so when they're on the dark gray one, you guys can see them up close. And the light gray one, you can see them because it doesn't match their fur. I know, right? There was a lot of that tonight. A whole lot of that tonight. We started out strong and stayed there. No, that first guy. Oh, I don't think it gets dumber than him. It certainly doesn't get lazier. Oh, Penny, honey, you missed the very first guy. He was awful. I highly recommend you go back and watch it from the start. He, bare minimum doesn't even cover it. No. Saying that he does the bare minimum is giving him too much credit. Yes, 3 p.m. tomorrow. Discord movie, Star Wars, Grogu, Mandalorian. Jerry's running it. And he got a new mic and headset. Today at 3 p.m. I'm sorry, it's past midnight. It's past my bedtime. I am tired. Saturday, Eileen. Saturday. Catterday. Okay. I need to go crawl into my comfy bed. Yes, today, the 23rd. Yeah, it's 12:15 a.m. here right now, which means I can do the new Wordle for the day. Tested the new headset. Yeah, whatever you were using before was awful, buddy. You could never hear you, ever. Kendall Smith. Hello, sweetie. So good to see you. Thank you guys all. Oh my goodness, I'm so sorry. I literally need to make it like 1 minute and 15 seconds in order to cross over the 2-hour threshold. But I don't even know if I can make it that long. Oh. There was actually there was a woman, I can't remember what state she was in, Larry, but she had tried adopting children born to street workers and addicts, and she had adopted like 4 kids, something like that. She was tired of seeing kids born to addicts. So she started a nonprofit program where she was paying women $200 to get their tubes tied. And for some reason, the county went absolutely bonkers about it. saying that it was inhumane and unjust and how dare she, and people were like saying there's other options, and she's like, look, we've been trying the other options. We've adopted these children. These children suffer daily because of the choices of their parents. If we can stop them from producing children that they don't take care of and that are born addicted, what is the downside to that? I am personally quite pro that scenario. I believe that there should be a funded program for people who are hardcore addicts to choose to get their tubes tied or to have a vasectomy. Because they don't need to have children that they can't care for, that they can't afford, and that will always come second to their addiction. If even that high on the list. Right. Yeah, nobody's forcing them. She's offering. And not only that, not only does she pay them the $200, she also pays for the procedure. So it's not like it's coming out of state funds or anything else. She and her husband, they were very blessed people. And she wanted to use their blessings to make a positive impact in the world. I so badly want my tubes tied. The medications that I'm on, I can't carry a child to term anyways, but just for the sake of making sure, I would love to have my tubes tied. I want it done so badly. I actually had it scheduled to be done the last time that I ended up hospitalized. I ended up hospitalized over the appointment period. So, and I just never got it rescheduled. Well, Jerry, I mean, that's already my life for the most part. It is like men, I've heard 2 days maximum. Some of them go back to work after the procedure, like straight back to the office. Women, it's a couple weeks. All right, guys. I passed the 2-hour mark. Now I'm going to go to bed. Be safe, be well, sleep sweet, and much love.